Welcome to What I Wish I Knew Then, Best Practices and Potential Pitfalls When Starting a Practice, brought to you by the American Bar Association Young Lawyers Division and our sponsor, Martindale Legal Marketing Network. For today's program, we will start with some webinar information and introductions, cover best practices and pitfalls, and conclude with an interactive panel discussion. The audience has joined this webinar in listen-only mode. You can submit text-based questions via the questions pane in the webinar control panel at any time. We will collect these and address as many as we can during the Q&A session. Unanswered questions will be responded to after the event. Finally, attendees will also receive a link to the webinar replay. Okay, we'd like to hand things over to Chelsea Langdon now. Chelsea is the Vice President of Sales and Operations at Martindale Nolo and has been with Martindale Nolo for 10 years. Chelsea, can you get us started?
Great. Thank you, Tracy, and thank you to the ABA Young Lawyers Division for having us back for another webinar. Today, I'd like to start by introducing our panelists. First, I'd like to welcome attorney Paul Little. Paul is an attorney joining us from Chicago. He's the managing partner of Little and Milan, a boutique law firm in the areas, focusing in the areas of criminal defense, family, and personal injury since 2005. Additionally, please help me welcome Eleanor Enzel. Eleanor is a Chicago-based attorney who formed Enzel Law in 2013. That's primarily focused on family law with an emphasis on cooperative divorce. Additionally, Nora is a member of the Chicago Bar Association, the Illinois State Bar Association, and the ABA. And finally, we also have attorney Roya Samargandhi. And after nearly 4 years in corporate practice, Roya began her own practice in 2015, working with low to moderate income clients in criminal defense and family law matters. She's also a proud alumna of the Chicago Bar Foundation's Justice Entrepreneurs Project and an active volunteer with the Chicago Volunteer Legal Services, First Defense Legal Aid, and the Family Defense Center. Thank you for joining us today, Eleanor and Paul and Roya. All right, let's go ahead and get started here. As Tracy mentioned, I am with the Martindale Legal Marketing Network. Our network of resources, including martindale.com, avvo.com, lawyers.com, and nolo.com, attract over 23 million consumers and generate over 100,000 requests from consumers searching for an attorney each month, making us the largest legal network online. Additionally, we've teamed up with the Chicago Bar Foundation Justice Entrepreneurs Project for this webinar. The Justice Entrepreneurs Project is a small business incubator that helps newer lawyers start innovative, socially conscious law practices serving low and middle income Chicagoans. The JEP draws on principles of entrepreneurship and experimentation common in the tech startup community to develop disruptive market-based models to improve access to legal services. Launched in 2013 and to date, the JEP has helped more than 50 attorneys build sustainable businesses serving this market. Moving on to some best practices and potential pitfalls, our team at Avvo surveyed 280 attorneys who started their own law practices and asked them what they wish they'd known and what pitfalls to avoid. We gathered the attorneys' insights, and we now have Eleanor, Paul, and Roya who will dive into the findings. They're also going to share their own experiences of starting their solo practices. So let me go ahead and introduce the first topic. Going solo. Going solo doesn't mean you're going it alone. Roya, would you like to start with this one?
Sure. And I think you can tell from our introduction that all three of us have started our own solo or small firms. Paul Lytle is currently in a partnership, but we've all faced that kind of trepidation of what that looks like and taking that initial leap in terms of starting our own practices, and I think we'd all agree that it's been super rewarding. Paul and Nora, what kind of forced you guys to finally take that step?
Well, I think an important point about this also is that going solo doesn't also mean that you couldn't find a job elsewhere. I think that's a bit of a stereotype that exists out there, and I think it's important to dispel that myth that going at it on your own or in a small firm doesn't mean because you didn't have any other choices, that it's a definitive choice to want to be your own boss and manage things. And for me, it was really important to work with the kind of people I wanted to work with and have control over like choosing my own clients. That was probably the most important thing for me. What about you?
Well, I had been in sales before going into law, and so one of the things that was really important to me was that I knew I had an acumen for sales, but I wanted to be in better control of my product. And so I knew that I wanted to do something that was service oriented, something that I myself could facilitate on my own, and also to the point that the other attorneys here have made in terms of being able to run my own schedule, run my own processes, that type of thing. That was something that was very attractive to me.
And I think it's also important to note, kind of going off of what Nora was articulating, that most attorneys in the U.S. work in solo or small firms. And so, you know, there's I think coming out of law school or even during law school, there's a big push towards kind of those big law, big dream jobs. And I'll speak just colloquially, most of my friends that started off in big law are now out of it. And there's a variety of reasons for that. But I think, you know, the autonomy that we've all touched on is something that's really attractive to a lot of people. But one of the things that people fear is that going out on their own means that they won't have resources upon which they can draw from. When you're in a bigger firm, there is not just the tangible resources, but also the intangible in terms of the knowledge base that you can pull from if you're facing a question that you've never faced, been in front of a judge you've never been in front of, and the like. But the reality is that there are a ton of resources out there for people that are going out on their own. There are legal incubators like the JEP, which we all frankly are part of or former members of. There's community resources such as Lawyerist and the like, and then there's of course bar associations, the ABA, your state bar association, and more local. So there's a ton of resources that you can pull from, and we'll kind of touch on additional ones throughout the presentation. But I think, you know, to dispel the myth, as Nora put it, not just that you couldn't find a job, but that you're making a proactive choice to run your own business and build the type of practice that you want to have, and that you are pulling from resources that are there and already available from you.
Great. That's really helpful insight. Thank you. Let's go ahead and move on to our next topic. What can you substitute for the knowledge sharing in a larger firm? Paul, would you like to start with this one?
Sure. So, you know, I think that one of the scariest things about going off and starting a small firm is that you don't know what you don't know. And a lot of that knowledge when you are in a larger firm is learned through osmosis. So it's learned around the water cooler, it's learned after work when you're having drinks, it's learned in meetings, etc. And you are acclimated to practice areas and to procedural norms based on your interactions with other attorneys in the firm and conversations that are being had. And so when you're alone or when you're in a very small firm, you have to figure out ways to substitute for that knowledge. And I think there's a couple of very good ways and easy ways to do that. First and foremost, I would recommend anyone who's on this list, those of you in particular who maybe new attorneys or younger attorneys, many of the bar associations are either free or they're very inexpensive for the first few years, and they're even, I think, valuably priced even in the later years. But many of those have listservs, and one of the things that I do in my practice is I subscribe to those listservs that are relevant to my practice. So I subscribe to a criminal defense listserv, I subscribe to a domestic relations listserv, and I subscribe to a litigation or a civil procedure listserv. And I try and make a point every day of as those questions come in across a listserv. And for those of you who don't know, a listserv is simply just, it's a list of lawyers you subscribe to. People can post and respond to questions, post questions and respond with answers. But I make it a point to read through each of those emails and at least skim them, because it may not be an issue that you're dealing with. It may not be an issue you're ever going to see, but it gives you awareness into issues that are out there, and it gives you an awareness into things that you should be looking for in your own cases, red flags you should be looking for, pitfalls you should be looking for. And I personally, which we'll talk a little bit more about managing and maintaining that information later, but I file each of those into email categories that are searchable later if I need to draw from that information. I'll let the other two attorneys here speak to it as well, but and then I just have one more point to make about another thing that I think is valuable. Roy, do you have any additional insight into that?
Yeah, and I think the listserv is valuable not just because of the questions that other people are asking, but I also think that you need to be able to humble yourself enough to recognize and ask the questions yourself. And that goes in part to another point I would make, in that you need to find and cultivate mentors. And that needs to be not just on substantive law, but also managing your practice, running a business, accounting. I know nothing about taxes, so I have a guru that I will shoot an email to, every once in a while. But maintaining those relationships, finding them and maintaining them, I think is really invaluable. And yeah, I have a mentor. Actually, I have multiple mentors for each aspect of my practice from a substantive law perspective. And it may be nothing more than, hey, are you free for coffee? Can I just talk over my cases with you? But I found that to be one of the more valuable things that have helped me substitute that knowledge share that I miss being part of a bigger firm, because I'm still leveraging those relationships that would otherwise have been there. What about you, Nora?
I would echo everything you guys said and just add a couple of more that have been helpful for me, which is observing in court, taking the time when your schedule is a little more free in the beginning and you don't have as many cases to go to your courtroom early or stay after and watch the other attorneys, what they're doing, how they're saying things, what they're filing. Observing the judge. I know Paul has a system for filing information on those, and I'm sure he'll talk about that later. But I find that really helpful in learning and being comfortable with kind of the procedures. And also, don't be afraid to ask other attorneys for help or ask them for a sample document. Sometimes when you're first starting out, all your social network, your friends, the people you went to law school, they're just starting out also. But if somebody else has done something even one time that you've never done, it would be helpful to you. So I wouldn't be afraid to reach out to your friends and your network, even if you feel like they're not more experienced than you, they still may have valuable insight or can point you in the right direction.
If I could just piggyback off one thing that Nora said is when you are in court and you do observe something that you think is extraordinarily good, or when you do observe the process for something that you think either you may encounter or something you have encountered, one thing that I do that I'm sort of shameless in is afterwards I will go to the clerk, get that case number, jot down that case number, and I will go to the clerk's office afterwards and just print up that case. And you can completely reverse engineer a better attorney's work. And you can then you can modify that work to fit your case. So you're taking somebody else's very good work. Of course, it's a matter of public record, but you can template some of their pleadings and you can map out the pleadings that they used to effectuate whatever their end was. I saw an incredibly smart attorney up in Rolling Meadows a few days ago, and she was doing a citation for assets, and it's something that I've always struggled with. What the process is and the process for really discovering someone's financial means and holding them to account, et cetera. And I was able to print out that entire case and to follow along with exactly what she did, and it gave me a very nice roadmap, complete with templates, as to how I could do the same thing for my clients.
And I'll say, Lauren had this conversation not that long ago, and even if it's an opposing counsel, I do have templatized pleadings that I use very frequently in my work, but I'm constantly modifying them based on what I've seen other attorneys do and the way that they've finessed language or captured something I hadn't contemplated. That, those are constantly works in progress. And so, don't, as Paul said, be a little shameless in your willingness to kind of capture that and make it your own.
Wow, that's great. Thank you. I think that there's a lot of really good action items that everybody can take away from that one. Thank you. Next topic here, number 3, you are your own brand. What can you do to increase visibility and establish credibility? Eleanor, do you want to take this one first?
Sure. I would say I think the best example is, for me, is what we're doing right now. Take opportunities to speak or to volunteer with bar associations or legal aid organizations. There's always people that are looking for attorneys to speak on a topic, even if you think you are just starting out and maybe don't have much to add. There's probably something that you do know that you can be of help to someone else. So these types of opportunities, speaking and teaching and sharing my experience, has been one of the best ways that I have kind of gotten my name out there and increased my visibility and credibility in my local market. I'm curious what other things that you guys have done.
Well, I'm going to say that Paul probably is not quite so shameless as to talk about himself during this topic, but I will. I think there is a benefit to presenting and carrying yourself a certain way in court, because that makes an impression not just on the judge and opposing counsels, but it makes an impression on the litigants and potential clients. And I think Paul is a supreme example of that. It's unfortunate we're not doing this as a video webinar, but anyone that practices in and around Cook County in either domestic relations or criminal defense, I think, recognizes Paul on site, and that's just a matter of the way he presents himself in court. And Paul, I'll take a gander and say that you do that very purposefully.
Well, thank you. That's a huge compliment. But I think really what's most important is that you figure out ways to set yourself apart from other attorneys. So you can do that in very easy ways. So you'll see there's most attorneys in court are, gray suited, very somber, and they are to some extent plodding along from one place to the other. So I would encourage everyone here to try and figure out what your brand is or what your distinguishing sort of signature thing is. And that can be anything. It can be a phrase, it could be the type of glasses you wear, it could be a red scarf, it can be a briefcase, it can be a certain color tie, it can be a lapel pin, but something so that when other attorneys and judges see you, there's a continuity of some sort of aesthetic that they will remember, they can associate with you. And it makes you appear, particularly when you're not as busy, very prolific. It also is a great conversation piece. So if you just have something that draws people's attention to it, you'll find that potential clients who might not be as willing to talk to you about, are you a lawyer, about their case, might start out by saying, I really like that scarf, or what is that lapel pin? And you can strike up a conversation with them. You'll talk about their case. You can attract clients that way as well. The other thing I think is really, really important, and that I think a lot of attorneys skip out on, is if you are a brand and you're an actual, like a retail brand or something like that, you would have created for yourself a list of rules as to how that brand is going to be presented. So the brand is going to be presented in this font, on this size, in this color, et cetera. And I would encourage you to spend some time as you open up your practices to think through that, to think, what are my pleadings going to look like? What are my business cards going to look like? What are my envelopes going to look like? And to really make sure that you maintain a consistency throughout, so that all of the extensions of your business look uniform and the same. So if someone says, wow, if someone looks at my business card, they could match that business card to my pleadings, right? So the way that my phone number is listed on my business card is the same as listed on my pleadings, is the same that's listed at the bottom of my letterhead, so that people begin to identify those things with you. And there's a number of reasons you want to do that, again, to make yourself more prolific. But the other reason is, presumably you're going to be doing good work, and you want people to associate that good work with you. You want, when a clerk sees your pleading, to be able to say, oh, I knew this pleading came from your office. Another thing that we do here is that we have, in addition to our envelopes, so we've got, I think they're the number 11 envelopes, we have an insert for those envelopes, and it's in our font, it's with our letterhead, and it says thank you. At the end of most cases, we'll write a handwritten thank you note, and at the bottom of that, so on the one side it says thank you, on the other side it has just our contact information. We'll write a handwritten note to the opposing counsel that just says, hey, thank you, it's a pleasure working with you, I appreciate your professionalism, whatever. And we'll also do that for clients. And that does two things. So one, it increases it does a couple things. It increases your brand visibility. Number two, it endures people to you. Number three, there's nothing, as Roy has just made so clear, there's nothing that people like more than a compliment. And so what they'll do is the people that you mail those cards to, they'll take that card because it's a compliment about them. It's, I like your professionalism, I learned something from you, etc. And where does that card go? It goes on their bulletin board. And it probably sits there for a year or 2 years. So every time that client thinks themselves or that attorney thinks themselves, gee, that other attorney was really nice, he did a great job, I really should refer him, etc. All they have to do is look up on their bulletin board. All they have to do is look up on their wall where they've posted this compliment that you've written about them. It keeps you top of mind. It costs almost nothing. And it's just a really good way to maintain that little sliver of real estate in everybody's head.
And if I can piggyback off of what Paul was just kind of alluding to, one of the biggest concerns when you initially launch your firm is, how am I going to get clients through the door?
Right.
How am I going to maintain a referral base? Where is that first client going to come from? And I think what's really, really important is that you get to a point where you can vet what is a good referral and what is not a good referral. And part of that goes to, where is that referral coming from? Is it coming from another attorney? If so, why? Is it, I've had attorneys who have been opposing counsels or potential opposing counsels refer a case to me because they say, I know you're reasonable and I can work with you. That's a huge compliment. And that takes relationship building. But not all referrals are equal, and I think you have to start creating a process by which you account for that. The other thing that I would say outside of the aesthetics of branding is creating a niche within the market for your firm. Part of the way that I've done that, and I think Paul and Nora would say the same, is by offering alternative pricing, offering limited scope services. That goes toward the type of clientele that I serve, which is low to moderate income people. And I can't tell you the number of people who have come to me from other firms, from bigger firms, that were only offering full scope representation. They realized they couldn't afford that. They came through my door and ultimately ended up being great clients and a great referral source.
Great. A lot of out of the box thinking there. Thank you so much. Go ahead and move on to the next topic here, which is one that I'm sure many of you have heard before. You have to spend money to make money. Roya, would you like to take this one first?
Sure. So, I think there are different avenues by which you can approach this. I took the pathway, and when I launched my firm, that I wanted to keep my overhead as low as possible, because I did have those concerns about how many clients were going to come through the door, and was I going to have the time to make sure my processes were in place, conflicts checked, things of that nature. And so initially I wanted to put my resources towards creating the foundational aspects that were going to ensure that my firm was successful long term. So that did include case management software. I don't think you need to go out and spend a ton of money for a really fancy office. But I think ultimately that may be, that may be down the line. But I think each person has to prioritize what they want. And this again goes back to the branding aspect. But I took the approach that I wanted to ensure that my firm was solid foundationally from the beginning, that I was capturing and had a method and a system to capture some of these things that we've talked about in terms of knowledge shares and things of that nature, and then let my overhead grow as my firm grew. What about you, Paul?
I think that's good advice. I think the main thing here, I think there's two main things. First is you should judge your expenses based on the value of the expense, so the return on the investment, as opposed to just the cost, right? So if you have something that's returning an investment, leaving aside the fact that something could return a better investment, if you are getting more money back than you put into it, particularly when you're starting out, it's good. That's a positive thing. And so if you can find things, if you want to ease into them and do them slowly, that's fine. Whether it's marketing, whatever it is, sort of easing into it slowly is fine. But you want to be judging it based on, if I'm spending $100 on marketing, I'm getting $120 back. I think that's a success, right? Because you can always, you can borrow $10,000 and get, $12,000 back. But I think even more importantly than that is to not be penny wise and pound foolish, so to speak. So what you really want to avoid is doing everything yourself because you don't want to spend money on anything. And that's something you should tell your clients too, right? Your clients could probably do what you do, right? They do a worse job of it. It would take them a lot longer. And in the end, it would be much more costly for them. And so you should apply that same principle to what you do, right? So one thing is, for whatever reason, I was very hesitant, right? I just kept putting off getting some sort of a means of electronic DocuSign. And I would PDF, I would send out the documents. I would say, listen, they can be returned to my office, by fax, by whatever, you can bring them in, etc. And I put it off for forever. Well, I ended up getting, and I got a solution. It's, I think, probably about $20 a month. The first time that I had someone DocuSign something, it was worth it already. So just by virtue of the convenience of sending it out, the ease and the ability of my client to get it back to me quickly, the avoidance of time wasted by documents that came in incorrectly or smudged or different color, etc., was so worth it that I can't believe I didn't do it earlier. And I'm sad I didn't do it earlier, because the value is in that I'm almost making money by using it at this point, because I can use that time, I can reallocate that time to somebody else. So you don't necessarily have to spend a ton of money, but what you do need to do is you do need to look at those things that you do well and those things that other people can do well and more efficiently. And you do need to spend the money on things that others do more efficiently than you do, so you can spend your time doing the things that you do most efficiently.
And to add to that, which are great points, I think, since one of the kind of overall topics is potential pitfalls, one that I've run into, and I would caution other people, is that it can be difficult to change either practice management software or credit card processing midstream once you're a couple years in. So take the time in the beginning, when you have more time than cases, to really invest in researching what tools are going to be best for you. Invest in your infrastructure in the beginning, and spend time researching and demoing and doing trials of the software, making sure they do everything that you want to do before you make the leap, and not even financially, but the commitment or the time to go down a particular road, because it can be difficult once you have all your information in the system to get it out and transfer to a new system, and your reporting is all off. And that even something as simple as credit card processing, I've found, is better to pick one and hope that it's going to be flexible enough to last you in the long run, than trying to kind of change as you go. And Paul's point about DocuSign and electronic signing is great. I agree with that completely. And I think, to reverse engineer that, think about where you're wasting time or where you're having problems, and try to find a solution to those problems. So I kind of have a running list of problems I'm trying to solve in my firm, whether it's getting documents back faster from my clients or getting paid more quickly. That's always one I think we're all working on. How do I solve those problems? Where am I having problems? Where am I wasting time? And is there a tool or a system that I can put into place that could help me solve that problem?
And I'll, going back to Nora's first point about kind of doing a test run on various software or capabilities, I'll throw in a plug for the ABA Tech Show I attended the tech show last April, I think, February, sometime this past spring. And one thing that I was at that time searching, a problem I was having was with my case management software. I had launched with a particular one at the start of my firm, was not happy with it and didn't feel like it met my needs. And obviously the tech show had a variety of established case management software, and some up and comers, and that gave me the opportunity to go around, have them all in one place. They were offering great deals, and I essentially was able to leverage that resource that the ABA offered by pulling all of those people together in one place and incentivizing them to really, put their best foot forward, and ended up from that encounter transitioning over, and they were, that was a great tool and resource that I was able to take advantage of. So I think that's a really great point that you make, Nora, because it is really hard once you're already kind of two-footed into a system or processes to turn back around. So be as flexible as you can and take the time in the beginning to do your research.
Yeah, good stuff. All right, next up is number 5. Just go ahead and get the slide to advance here. Okay, give us just a second here. All right, starting from scratch doesn't mean you should take every case that comes through the door. And you guys touched on this a little bit earlier when you were talking about referrals. Paul, do you want to kick this one off?
Sure. I think that you'll hear from a lot of people that know what they're talking about, that you should limit your practice and you should try and establish parameters of what type of client you want to serve and what type of practice you want to serve that client by. And it is so incredibly tempting in the beginning when you are really hungry for clients and you really need revenue to stray from those parameters. And so I would say, just generally speaking, without talking about individual clients and gut instincts, which I'm sure the other attorneys here will speak about, is to try and hold true to those parameters and to not stray. I think that there's a couple of reasons why it's important. One is you're not doing those clients any favor, right? The more that you sort of moonlight into other practice areas, the more that you risk not knowing what you're doing, not being fully aware of all the issues that should come up, not being familiar with the policies and the practice, et cetera, and you're not really effectively, competently representing those clients in that area to an extent that another attorney who's more familiar with it would. And additionally, you yourself, particularly if you're a good attorney, and I'd imagine everyone on this phone call is, I know that everyone in this room is, you're so conscious of doing a good job that you are probably going to waste 2, 3, 4 times the amount of time that you would normally on a case to try and get yourself up to speed, and also likely fail to get yourself up to speed. So it's inefficient. It is a losing proposition in terms of a value proposition. It's bad for you. It's bad for the client. You're not making any money. The client isn't being served well. So my advice, generally speaking, is, and what you do can evolve. It can change. It can become more specific. It can become slightly more generalized. But you need to have the parameters around your business. You need to have principles of both geographical and substantive scope of practice that you say, when a client comes in, I'm going to draw a line here, right? And I'm going to refer them out to somebody better suited for this, and really be honest with yourself and then really hold yourself to task. I don't think I've ever taken a case outside of what I committed to being my area that I haven't regretted in some way, shape, or form.
And I'll piggyback off of what Paul just said and then kind of switch gears a little bit from a different perspective. I think we're taking the opportunity to refer out a case that maybe is outside your practice area to another attorney going back to what we were talking about before, ingratiates yourself to that other attorney. You can take that as an opportunity to build a reciprocal relationship, or just get on that attorney's good graces. But I think, you know, there are benefits that you could see down the line from not taking that case just by virtue of the fact that you're providing an appropriate and reasonable referral. The client, as Paul just articulated, will be better served, but you're also kind of building your brand and building your name recognition and those relationships that'll serve you long term. On the other side, even if it's a case that is within your self-determined practice areas, that may not be a client that's a good fit for you. It may be that they don't share your litigation philosophy. They may not have appropriate expectations. I have a running list of red flags that I will kind of go through during my consultation, and a client is kind of repeatedly checking off those red flags. They're likely a client that I'm going to decline. And I know, especially in the beginning, where revenue streams are lean, it's very tempting to take that case on just because you need the money. But the case that you don't take is the best money you don't make, because the headache and the all of the things that go into an ill-fitting client, whether that be practice area, as Paul was talking about, or just from a personality perspective, it's never going to make that amount of money that you charge worth it.
I agree, and I would add to that just a little bit and say that, I mean, and I think we could do a whole additional webinar on client screening and client interviewing, and I think Roy did a good job summarizing that. One thing that I found helpful in interviewing new clients is to really look at how they are when trying to hire you. If they're blowing up your phone all the time, emailing you, calling you, texting you,
just looking for the cheapest price.
Yeah, or price shopping, you know, that they're showing you how it's going to be to work with them. So listen to what they're saying and what they're showing you. And also, they're never more likely to pay you or to want to pay you than right in the beginning. You know, they want to hire you, they need help. If they're having a hard time coming up with the money or meeting the obligations that you've set on them or that they've committed to, it's not necessarily, in my experience, it doesn't generally get better than that. They're never more likely to pay you than right in the beginning. And if they're struggling with that, that's probably going to be a continued struggle. And as solos and small firms, getting paid is one of the biggest challenges. I think we all struggle with it at different points in time. So be aware of that. And I think Roy's point about referrals is great. I just summarize it and say the best way to get a referral is to give a referral. So when you refer a case out to someone else, they think of you, they might want to return the favor if they've got a client that might be a good fit for you. And depending on your, you know, jurisdictional rules or ethic rules where you practice, you may want to consider co-counseling with that other attorney. If it's a case that you're referring out because it's over your head, but you'd like to learn how to do that, or it's a little more complicated or a little more difficult, it might be worth trying to partner with a more experienced attorney so you can maintain the case and kind of learn how to do it without risking malpractice by doing something that's outside of over your head.
And Nora, I want to return to one point that you made. You mentioned interviewing potential clients, and I think that brings up a implicit point that you made in that, yes, you are bringing in potential clients who you want to buy into your brand and your firm philosophy and all of that, but at the same time, you are interviewing them. And so it shouldn't be just a one-way street. You should be taking that opportunity to evaluate the client just as much as they're evaluating you.
Great, good stuff. Next topic, go ahead and, is going to be do it right and write it down. Invest time and resources into planning and documenting new processes. Eleanor, do you want to kick this one off?
Sure. Yeah, and I just have one quick point to make here, and then I'm going to punt to Paul because I know he's done a lot of this in his practice and has some really good insights here. But one thing that I found very helpful in my own practice is checklists. I use a lot of checklists. I read the Checklist Manifesto book a few years ago, and it really kind of changed my philosophy on a lot of things. And even things you do all of the time, having a checklist and making sure that you don't skip any steps or miss anything, even things that you do all the time, you'd be surprised how often you might skip steps or make a mistake if you don't have a checklist. But I'm definitely going to punt this one to Paul because I know he has a lot to add here.
Yeah, so I always think about this as sort of off on a tangent, but the United States developed a material to hold the pieces in place of nuclear weapons called fog bank, and they spent trillions of dollars doing it. And in the years since they did that, we've completely forgotten how to make that material. And so that should be and we're going to spend trillions of dollars to reinvent it. And so that should be a good point to remember when you are doing your own work, that when you put all sorts of work and time and energy and research into developing something, whether it is a strategy for a case, or even sometimes even the processes to get through or by a Cook County clerk, right? Who do I contact? What do I need to give them? What information I need to do? When you're done with that, the last thing you want to do is take the time to document it. You're exhausted. You've been through this incredible fight to hopefully accomplish your objectives, and you think, I'll never forget this. You will forget it, and you'll probably forget it next week. So the first thing you should do is take the time to really, to the best of your ability, to process map or template. It is so worth your time. It is not upfront, but moving forward, it will become one of the most valuable tools in your practice. So take the time to document what you did, how you did it, who you spoke to, what those secret phone numbers are, where those secret email addresses are, what is the specific information they needed, when the people were available, etc. Really take the time to document all of that hard work that you do, and to document it and then to store it in some sort of a way, however you want to do it, but to come with some sort of a filing system so that you can very quickly go back and re-access that information the next time that you need to do it. And you'll find some of the most complicated things are issues that will be perennial to your business. For example, one of the things in domestic relations law that I think that we all encounter every once in a while, but not routinely, is the registering of an administrative order to bring it under the jurisdiction of a circuit court. It comes up all the time. It's incredibly specific and laborious, and typically the clients that need you to effectuate that process don't have a lot of money. So in order to serve those clients who may be lower income clients, you have to figure out a way to complete that process efficiently and effectively. And the way to do that is to have that process down pat and to have everything templated and ready to go. So really, when you've done something very well, that's only half the job, or maybe even a third of the job. The other 2/3 of the job is really making sure that you put in place the some sort of a treasure map for yourself that you can use later on to go back and to find that information. And I'll talk just really briefly on one other thing before I pass it on to one of the other attorneys here, but that also goes for things that you might discover that are peculiarities about either particular courthouses or judges. And I think this is just a valuable tool that we employ here, is in our practice management software, whatever you use. And if you don't use practice management software, even just a file in your office, whatever it is, but we have a contact for each judge, and we have each courthouse set up as a corporation. And so what that allows us to do in our practice management software is every time we're before that judge or in that courthouse, we can very simply just add a note or append a note to that contact or to that corporation to say, Judge Jones loves dogs, right? Or Judge Rodriguez requires you to be on time and does not want you to speak before she speaks to you. Little things like that are really, really important. And if you have everything compiled in easily accessible location, you can very quickly refresh yourself either in court. Oftentimes, your practice management has an app, or you're using a tablet, or before you go to court. It's really, really helpful. It's a great way to take the information that you have and to make the most of it.
And I'll just add, I think, this is something that I struggle with in terms of taking the time to go back, as Paul's talking about, and capturing all of this information. So I won't feign to speak from a great practice myself, but what I will say is I think it's important not just for your own benefit, I have a horrible memory, and being able to have that information on hand is great, because you are going to get bogged down with the minutia of your actual cases. But also, if you're thinking about the growth of your firm long term, having these checklists, having this information captured in a space that can be easily shared is something that's going to be invaluable to you as you start thinking about growing your firm, bringing on an associate, bringing on a clerk. They'll have that information on the ready, and it won't just necessitate you sitting down with them each and every task that they need to do and trying to verbalize and articulate what happens. They're going to have something that they can reference because you've taken that time on the back end to capture it all.
I agree.
Yeah, I think that's great insight. Go ahead.
Oh, I was just going to say that I agree, and I do what Paul does and keep contact files on the judges. I also add the names of the judge's clerk and coordinator whenever I can figure out what their names are. Sometimes they have name tags, sometimes they don't. I find that to be really helpful, and also learning the court staff and having them learn you and your name. I think that we all recognize as practicing that the people around the judge have as much influence sometimes over how your case is processed and handled as the judge themselves. So I think it's really helpful to start to develop good relationships with those folks, because they can be very helpful in your practice.
Or not helpful.
Or not helpful. So yeah, exactly. And so I found that to be very valuable as well.
Great. Okay. Number 7 is, I think it's incredibly relevant, especially in today's kind of online focused world. Always ask for client reviews. Feedback always helps you improve. Roya, would you like to take this one first?
Sure. This is something that I think is important, not just at the close of your case, but also during your case, is inviting feedback from your clients in terms of what's working and what's not. And I should expand that not just to your clients, but to other people you encounter, opposing counsels and the like. I will say, as part of my checklist for closing out my file for a case, is that I do send my client a survey that I've created specific to my practice and invite that feedback. And I also include links to things like Avvo profiles. There's, I think, a link to Google. I previously had a Facebook page, so there's a link to that as well. That is important, not just because it helps you figure out what's working and what's not, and be receptive and accommodating to that feedback that you're getting. But hopefully those reviews and that feedback you're receiving is positive. And that in itself goes back to creating a brand and capturing those referrals. I find in the community that I serve, being low to moderate income individuals, they may or may not know an attorney to whom they're going to go and ask for a referral. They may literally just Google family law attorney Chicago. And so having those positive reviews when they're doing that simple Google search is something that's going to delineate my practice apart from another attorney. But I think what I've found to be the most helpful in the development of my firm is that kind of one-on-one insight that I'm gaining from my clients through the direct survey that they're providing to me.
Perfect. Anyone else?
No, I just
All right. Go ahead.
I was just going to piggyback on what Roy said, that I think if asking for feedback is really important, and if you're sitting here thinking that you're afraid to ask your clients for feedback because you're afraid of what they're going to say, then I think that you know that you have a problem that you need to solve.
And that's exactly when you should be asking for feedback.
Exactly. So you can improve those processes.
Great. All right, we're going to go ahead and move on to number 8. And I think that, again, we touched on this with topic number 6 a little bit. How can you reuse and repurpose information and resources to maximize efficiency? Paul, do you want to start with this one?
Yeah, so we did touch on some of that, and I actually had forgotten that some of that was going to be discussed in this slide. But I think that we've actually talked about a lot of it. I'll just give you anecdotally what my process is. So when I close out a case, I have a checklist for all the information that must be captured electronically on that case. And that includes things like whatever the agreement was in writing, whatever the conclusion of legal representation is in writing, a copy of whatever the final orders were, and then it's contact information for the attorneys that were involved, contact information for the adverse party, also for your client, for the judge, and there's a few other things. But once that is recorded, what I then do is I take my case file and I go through that file and I take out, first of all, I do a scan through the file to determine if there's anything that I can use that we touched on earlier. So are there any pleadings that either I did or opposing counsel did that I think are pleadings that could be made into a template? Are there any phone numbers in there, or are there any email addresses in there that I used during that case that I want to record or include in a file to access later? A really, really important one is transcripts. So in a lot of cases, you are ordering, but you're not paying for it. Your client's paying for transcripts. So this is a resource that you're not even paying for. We take all of our transcripts out, we scan them, and then we print them, and we have in our office a transcript library. So the next time that I have a case with those issues or a case that's at that stage, I can pull that transcript, I can read it before, and it can give me either inspiration or it can also be used as a checklist to make sure I'm covering all the things that I need. And then finally, just from a very basic level is, I'm removing all of the files, besides the actual file folder, I'm removing individual files, paper clips, binder clips, etc., that can be reused again later, and then we store that final file. But when you're talking about keeping costs low, I mean, that's the stuff, again, you don't want to spend money on. You can reuse, and looking for those places that you can both reuse supplies and also where you can reuse information.
Great. Anybody else?
One thing that I hope people take from this webinar just generally is that an important part of launching your own firm is having the humility to constantly be learning and improving. And so I think that is a thread that comes along through what we've all been talking about, is repurposing not only what you've done in the past, but what you've seen others do, making sure you're capturing that for your own utilization down the line. Because I can tell you for myself, things that I drafted 3 years ago, I cringe at reading now, thinking how much better I could have done it. Because you're constantly learning, or you should be, and you should be implementing that what you're learning and how you're developing in your everyday practice so that you can better serve your clients and be more profitable, which I think would be everyone's goal as a solo small practitioner or in a big firm.
And what I would hope people take away also is not being afraid to ask for help, that there are a lot of people around you, wherever you are, that are invested in your success and want you to be successful, whether it's friends, family, fellow lawyers, people you went to law school with. One of the best ways to get people invested in success is to ask them for help. If someone gives you advice on solving a problem or on an accountant or anything like that, they are invested then in making sure that their advice is correct and works out well for you. And so that's a good way to draw people in and kind of build your support system. So on the same point as Roy said about being about having humility, I think asking for help is really important. And there's a lot of people out there that want you to be successful.
Great. All right. Well, that's going to go ahead and conclude the topics discussion. So thank you, Eleanor, Paul, and Roya, for sharing your experience and insight. What I'd like to move on to is the Q&A portion here. So we did ask each attendee to submit questions at the time of registration, and I'd like to start to try and address those. I know we have a few minutes left here. So we talked, there were some questions around branding, and because we addressed that earlier, I'm going to go ahead and move on to a couple other topics. So the first one here is, what's the best way for new attorneys to gain experience, including co-counseling how-tos? Paul or Eleanor or Roya, which one of you would like to start with that?
I think I touched on co-counseling briefly when we were speaking earlier about if a case comes in that is a bit over your head, finding other attorneys to co-counsel with can be as simple as other people that are in your personal network, or a great resources going into court and observing people, see who the good attorneys are, someone that you would like to work with or like to learn from. Maybe it's attorneys that you've had a previous case against and you thought they were very good. One of the best ways I've found to get practical experience is volunteering. And I think that's something that we haven't yet mentioned in this presentation, but there are legal aid organizations in every state that have plenty of cases that they would like to give you pro bono. And oftentimes they have very good training resources and supervising attorneys that can help you learn how to do something. If you've never done an order of protection before, but you'd like to learn how to do that, or you'd like to take cases in that and you don't know how to do it, I'm sure there's a legal aid organization that would love to have you volunteer, that would be glad to teach you how to do that in exchange for having you volunteer and take a pro bono case for them. So that would be my suggestion.
One other thing that I would offer up is making sure you are letting other attorneys know your availability for coverage. And what that entails is you know, if they have a conflict and have to be in one courthouse or two courthouses at the same time, I should say. I think that's really invaluable, especially when you're first starting out, because it gives you the opportunity to get before a judge, get into a courthouse that you may not have yet had the opportunity without the pressure that comes with kind of a full representation and taking on the case on your own. You can go in limited issue with the advice, consent, and backup of the attorney you're covering for, but still get some comfortability with the machinations of that courtroom. And, you know, there's little things when you're first starting out that you don't know, just in terms of how to traverse the courthouse and how to get through security and things of that nature. And I think making yourself available for coverage work, is a great source of income in the beginning, but also gives you an opportunity to get some experience, practical experience that you may not have otherwise had yet.
Great. I think we might have time to squeeze in one more here. Let's see. What did you spend the majority of your time on in the first year your practice was open? Roya or Paul, do you want to take this one?
Yeah, I'll take it. I mean, I think the majority of the time that I spent in my first year of practice really had to do with the substantive law and making sure that I was competently and zealously representing clients. I think that is, you know, you need to run a good business, and without having a good business, you can't practice law. But at the end of the day, what's most fundamental to that business is your product. And if you don't have a good product, and if you're not representing your client well, no matter how efficiently you're running a business, you won't have one for very long. So I think when I think back in the first year, it was really spending most of my time making sure that the clients were served well, that I understood the law, that I understood the process. And then maybe as a second would be developing the process by which I would service those clients. And I think to that end too, I would encourage everyone to take some time and to brainstorm through just outlining, okay, what are the steps, not just in a case, but in client service, right? So from when a client comes to my door, what are the things I'm going to be doing? Are they going to be filling out a survey regarding their background information? After they fill out the survey, what am I going to do next? Do we then set up a phone interview? Do we set up an in-person interview? After the phone interview or the in-person interview, do I then write them a letter and accept a case or decline a case? What is the next step after that, right? And after I appear in court on their behalf, or there's an important update, what does that look like? What specific information do I send them? How do I send it to them? So I would say, those two things. One, making sure that your product is solid, and then number two, making sure the way that you deliver that product to the client is uniform and effective.
Great, thank you. Well, we're right up against the hour here, so thank you again, Paul, Eleanor, and Roya. Your insight was much appreciated. That's all the time we have for questions. I do want to thank everybody for joining us today and hope you enjoyed the presentation. As mentioned earlier, a replay of this webinar will be provided to all attendees and registrants after the event. and have a great day. Bye.